learners. My name is Miss Ngidi, and today we'll be doing our very first lesson for business studies. I'll be taking you guys through the macro environment, impacts of recent legislation on business. Okay, as we all know, the macro environment forms part of the three environments, namely your micro, your markets, and your macro environment. So we need to understand the recent legislation, that it is there to ensure a path to equality for all people. Many changes were made to existing laws and many new laws were introduced. These recent changes were developed in response to demands for redress and equity and have changed the impact that the macro environment has on a business. So just to outline in overall the nature and the purpose, I've given you guys notes. I made notes for you guys for all the 8 acts. But today all I'm doing is just taking you through these notes in order for you to understand them. But I'll just summarize everything and point out what is important. Okay, so the aim and the nature actually goes together for the Skills Development Act. Because, okay, the aim of the act was that it was developed in response to the demands for redress and equity. So, let me just write down. Act was developed in response to the demands for redress and equity. Okay, that is the main aim of the act. Okay, that historically disadvantaged people also get opportunities to gain skills so that they become more employable. So we are redressing that issue, that okay, there are people who were historically disadvantaged in the past, so now we should also include them and make them more employable to people by giving them the necessary skills that they need in order to become employable. All right, and then the idea behind this act, which is basically the nature of the act, is that a skilled workforce should lead to improved productivity, employment, increased employment, and therefore social development. So it focuses on 3 things. Number 1, it's improved productivity, and then secondly, it's increased employment, and then thirdly, social development. Social development. Okay, and then we move on to the purpose of the act. And in a nutshell, I would say the purpose of the act is basically about developing and improving workers' skills, okay? And therefore that improves productivity in the workplace, because the more a worker becomes skilled and efficient, obviously productivity is improved, because they are able to work well under pressure, they are able to arrive at work on time, and they are able to use the machinery that is there properly. Okay, they are able to understand the nature of the workplace as a whole, and therefore there's a smooth running of the business. And then another purpose of the act is that it ensures quality training in the workplace. So employees are properly trained. They go through the training process thoroughly in such a way that they are able to master it. Okay, and then thirdly, it encourages businesses to improve the skills of their workers. Okay, so that is quite linked to the first 2 that I've already mentioned. All right, and then we move on to understanding the difference between SETAs and National Skills Authority. So we have SETAs, and then we have National Skills. Okay, let me just write its abbreviation. National Skills Authority. Okay, so these 2 are interlinked because the Sector Education and Training Authorities, which is our SETAs, it's an organization that is established organization established for economic sectors. Okay. And then the National Skills Authority, it's just basically an authority figure that advises. It advises the Department of Labor, okay, on national skills development policies. So basically what's right and what's wrong, what a business should do and what a business should try and avoid. Okay, so these two organizations that I've mentioned have the roles that they should do, such as they have to approve skills plans and annual training reports, and they also have to allocate grants to companies complying with the requirements of the Skills Development Act, so that employees can earn like a stipend when they are undergoing the learnership. Okay, and they also manage learnerships and training in each and every SETA, all right? And then they also promote learnerships by identifying suitable workplaces for practical work experience, okay? For example, when somebody is learning how to sew or somebody is learning how to probably build a bridge, you need to allocate that person in the correct learnership program, okay, in a correct suitable workplace or organization. You can't allocate somebody who's trying to learn how to sew at Cecil, because that is not what Cecil does, all right? So you need to be appropriate in everything you do, and it has to be in line with that particular learnership, all right? And then we move on to, I think I should give you guys examples of SETAs. So we have insurance, SETAs, we have service SETAs, we have education, training and development SETAs. And then we also have wholesale and resale SETAs. Wholesale and resale SETAs. All right, so those are the examples of SETAs that we have. And then we move on to the advantages and disadvantages of this act on both employees and employers. So for employees, the advantage would be that they get to improve the quality of life of workers. So they would be in a higher salary band after training has been completed. So let me just highlight the advantages. It improves the quality of life so that they can earn a higher salary band after training has been completed. Another one is that this act promotes self-employment, as employees are equipped to start their own business. Okay, and this also leads to job creation. Okay, and then there's also an improved productivity in the workplace due to employees obtaining better skills, because now they are able to work under pressure. Okay, so that is just it when it comes to the advantages. And then the disadvantages is that employees are forced to do training that they don't necessarily want to do. Okay, so maybe an employee just wants to do the theory part of the learnership, such as learning how to sew and understanding what is needed, but it doesn't end there. You actually need to put it into practice so that you can see if you are able to do it or not, and where you need to improve, and so on and so on. So many employees are probably forced to do the training that they don't necessarily want to do. Okay, And then while employees are being trained, their workload and deadline remain. So this can place additional pressure on them. Let's say you have this training to undergo, but at the same time, you have these assignments and tests to study for in the learnership program, which are part of the learnership program. So that is like having more work to do, and that additionally places pressure on people attending this particular learnership. Okay. And then we move on to the advantages and disadvantages for employers. Okay, so for employers, I can say it's the advantages are that employers are encouraged to use the workplace as a learning environment where they can learn practical applications of their own jobs. Okay, so this means that employers are currently gaining new skills as well, because we know the saying that says we learn new things every day. So once these employers partake in helping these people gain new skills, the employers gain new skills, they themselves also learn perfection in a way, because they keep on gaining practical applications of their jobs each and every day that they undergo this learnership program. So let me just highlight for you guys. Learning environment. Okay, to learn practical applications of their own job. And then another advantage for employees is that employers employ people who find it difficult to be employed. And this qualifies employers for a learnership incentive paid by most leaders. So that can help with cash flow in the business, because they can use that money to do things that are really important for their business or organization. And another advantage is that employers are expected to encourage their workers to participate in leadership and training programs. This entitles employers to tax concessions. So this is an added advantage for employers. Okay, and then we move on to the disadvantages for employers in this particular act, which is that extra administrative resources are required for data capturing. Okay, so that is actually an extra burden, because now they need to buy maybe another computer or another storage software, you see. So that is added work for the employer side, because they have to spend probably out of budget. Okay, or they have to improvise and see what they are able to come up with. And then another disadvantage is that incentives are only paid to employers when they employ people from designated groups. Designated groups could be, let's say they say between 18 and 35 years, okay, or from backgrounds whereby your parents earn less than a certain amount of money. So that is what they mean when they say designated groups. Okay, so if you are below 18 and you want to join a learnership, you cannot, because you can, but the employer won't get that incentive that they need. And then if you are above 35, an employer will also lose out on that incentive that they usually get. And if you're not from a background that is that they actually want, like not exactly like a disadvantaged background, then an employer will not get that incentive. So that is why when employers are advertising that they have a certain leadership in the workplace, they strictly quote that they want people between the ages of 18 and 35, or they want people whose parents actually earn a certain amount of money. Okay, so we move on to the next part, which is the rights of employees and the rights of employers. Okay, for employees, the rights for them would be that they are entitled to enroll in skills development programs. So an employer can never deny an employee the opportunity to enroll in a skills development program. And another right for employees is that they are entitled to participate in leadership programs. Okay, so that's good for employees, because they are able to continuously improve their skills in the workplace and come out as perfectionists, or rather specialists in that particular field, because they've undergone the training that they need to do. And then the rights for employees is that they may claim 70% of all levies paid by submitting a workplace skills plan and give evidence that it was carried out. Okay, so that also helps with cash flow as well, because let's say an employer carries out a leadership program or a workshop on that particular day, and they give evidence like videos and people presenting, or of them as employers presenting and helping people to acquire those practical skills. And then at the end of the day, or at the end of that workshop, they submit a workplace skills plan, and then they can reclaim 70% of all the levies that were paid. Okay, and then another point is that they may claim a leadership incentive payment for employing workers who find it difficult to be employed due to their lack of skills. Okay, so that also helps with cash flow in the business as well. And then we move on to compliance and non-compliance. So basically here is an employee doing what is right, and what is wrong. Okay, so what is right and what is expected, or rather what is expected and what is not expected. So what is expected for a business is that they should register with SARS, okay? Register with SARS, and then they must also provide all employees with opportunity to improve their skills, okay? So they mustn't discriminate against employees. All employees should be given an equal chance. And then when it comes to non-compliance, employers can be fined or given a jail sentence of up to 1 year if they neglect to pay levies, or if they provide false information in a statement, or they neglect to submit documents. So basically this is just an outline of what is wrong and what is right. And then we move on to our second act, which is the Labor Relations Act of 1995, sorry. Okay, so the aim of this act is it basically gives a comprehensive outline of employer and employee rights. Okay, so it tells us these are the employer's rights, these are the employees' rights. So it basically gives us an outline of employee and employer rights. And then the nature of the act is that it regulates the relationships between employees and their unions, and also employers and their organizations. So these are two relationships that the act regulates. The first one is employers and their unions. Then the second one is employers and their organizations. So these are two relationships. And then the purpose of the act is basically that it provides simple procedures for the registration of trade unions and employers' organization. And then it also allows workplace forums where employees participate in decision making. So it doesn't mean that with this act the employer has the final say. They don't, because the employer also has to hear out employees' opinions and views of a particular decision that actually has to be made. And then it endorses the right to strike against retrenchments and facilitates labor disputes. So when an employer retrenches someone, the employer can't just expect the person to say, oh, okay, that's fine. Well, it's not. The employer must brace themselves that the employees may actually file for a labor dispute, or, take them to the CCMA or things like that. And then they have to ensure that whatever decision is made benefits both the employer and the employee, such as that maybe the employee that was retrenched is given a particular sort of probably like incentive, okay, or compensation for being retrenched. And then we move on to the advantages and disadvantages for the employers. The first one is that the Act provides mechanisms such as statutory councils, collective bargaining, and the CCMA to settle labor disputes. And I think that is really an advantage, because the employer doesn't waste money on lawyers and everything, because the Act actually provides for statutory councils and collective bargaining and the CCMA to handle labor disputes. And then another advantage is that the Act, it provides protection for employees who embark on lawful lockouts when negotiations between management and union representatives have failed. Okay, and then it also entitles employees to compensation from the labor courts if they suffered losses as a result of unprotected strikes. So those are the advantages of employers, that whatever happens, let's say employees strike and they damage the property of a business or resources, an employer is entitled to compensation from the labor courts if they suffered those particular losses as a result of only unprotected strikes. And then the disadvantages, on the other hand, is that the consequences of legal strikes impact heavily and profitably on business, because that business loses out on production for that entire week or that entire day, so that is a disadvantage, because now no profit is coming in as production is at a standstill. And then the negotiation process can be very time consuming, okay, because let's say a decision is not met on that particular day, or they cannot agree on one thing, so the negotiation process drags on and on and on, and time is being wasted. Okay, so there is another disadvantage on employees. And when time is being wasted, obviously production and productivity is also suffering, because productivity is not happening and no profit is coming in as well. So as I said, these points are actually linked to each other. And then the last disadvantage is that employers have to employ designated specialists to deal with labor issues, which can be costly. Okay, so in order for the employers to not lose more than they've already lost, it's better for them to hire somebody who knows how to handle labor disputes, somebody who is a specialist in that particular field, and that can really be quite costly for businesses. Okay, and then we move on to the advantages and disadvantages on employers now. So just to outline them for you, the advantage for employees is that the act protects employees who partake in lawful strikes. Okay, so if you have drafted a memorandum as employees to say this is what we want, and this is how the employer can help us, then that act is the act protects such strikes because they are lawful. Procedure was followed. Okay, and then another advantage is that it protects employees against unfair dismissal by providing stringent guidelines. Okay, so as we all know, an employer and employee have to sign a contract when starting in the workplace, when an employee is starting in the workplace, so they need to follow those guidelines. Okay, and the act now protects employees if they were unfairly dismissed. All right, and then workplace forums allow for employees to meet with their employers and discuss work-related issues. So that is another advantage, if employees are able to meet directly with the employers and not perhaps pass on a message or report to the secretary first or somebody who's just under the CEO. It's more better if the employee can speak directly to the person in charge of the business regarding to work-related issues, because they're able to resolve that matter accordingly. But on the downside, there are also disadvantages for employees, such as unions often enforce strikes for all union members, even if particular members do not want to strike. So let's say 100 employees sign a petition that they want to strike because of such reasons. A union is forced to now implement that strike, even though other employees may disagree and say they do not want to strike. Okay, because the union has to cater for all employees, not just a certain percentage of employees. Okay, and then another thing is, now during these times of a certain number of employees wanting to strike, it has a negative impact on households, because remember, some workplaces pay employees hourly, okay, or daily or weekly even. So can you imagine if a certain number of employees are striking for 10 hours, or they're striking for that whole week, or they're striking for that whole day, then they lose out on their wages that they were supposed to earn. And then obviously this has a negative impact on certain households, because they actually survive on this money that they are now not getting due to the strike. And then the last disadvantage is that safety of workers are at risk, as strikes can turn violent, and they can when let's say some employees become aggressive and end up destroying property, and that now forces the employer to hire a private company, a private security company to look after their building, or call the police to intervene. And we all know that it can turn out really nasty, and then some workers might get injured or their safety might be at stake. Okay, and then we move on to the rights of employers and employees. Okay, so with the rights of employers and employees, I could say that it is the rights of employers have a right to, let me just write down for you guys. Employers have a right to dismiss employees. Rights of employees. Okay, so employers can dismiss employees for misconduct. Okay, so that is their rights. As much as it's unfair to dismiss someone, but employers do have a right to dismiss employees for misconduct. Misconduct based on violence that occurs during a strike, or stealing. Okay, or as well as, so that's one reason. And then the second reason would be if an employee is incapable due to ill health. Okay, or operational reasons. So an employer can dismiss an employee on these reasons that I've mentioned. Okay, and then we also have the rights of employees now. We also have the rights of employees, and that is that employees who are trade union representative are entitled to reasonable time off. Okay, so that is the rights of employees. They are entitled to reasonable time off with pay during working hours to perform their functions. So that tells us that an employee can now say to someone, I'm no work, no pay. It doesn't apply in this instance because trade union representatives are entitled to reasonable time off with pay. So the no work, no pay situation does not apply here. And then another right is that an employee can claim compensation from the labor courts if they suffer any losses as a result of unprotected strike or unprotected lockout. And then if unfairly dismissed, the labor courts can request reinstatement of employees in order to protect their social economic interests. And then we have compliance and non-compliance in the act. Okay, so for this, it's basically about knowing what is right and what is wrong. Okay, as I said in the first act. Okay, so what is right here is that employees may not prevent employees from joining trade unions or participating in union activities. And then employees also have to disclose information about work issues to union representatives. And then lastly, employers have to agree to an agency shop for non-union members. Okay, and then non-compliance, this is what is wrong. It's when employers dismiss employees illegally or unfairly, so without a justified reason. Okay, and then employers refusing to give members of a workplace forum reasonable time off with pay during working hours. So all these show that now an employer is not complying with the act. And then employers refusing union representatives leave for trade activities. Okay, so under no circumstances is an employer allowed to do these three things that I've just mentioned and underlined for you guys. And then we now move on to the third act. We now move on to the third act, which is the Employment Equity Act. Okay, so with the Employment Equity Act, all that is important here is to know that this act is there to regulate unfair discrimination in the workplace. Okay, so it aims to solve that. Okay, so it promotes equity in employment situations and regulates affirmative action. And then the nature of the act is that it was introduced as a result of discriminatory laws and practices implemented during apartheid. So it aims to rectify that. So it aims to rectify. Rectify unfair practices that were implemented during apartheid. Okay, and then the purpose of the act is that it ensures that employees who work for the same employer and who perform the same work do so under the same conditions. So it ensures fairity in the workplace, okay, that all employees are treated the same way. Okay, and then adding to the purpose of the Employment Equity Act is that it ensures that no discrimination on grounds of gender in the workplace takes place. Okay, so whether you're male or female, and if you're doing this, if you're holding actually the same position in the workplace, you must get paid fairly. Not that the male needs to earn more than the female. Okay. And then it also promotes equal opportunity and fair treatment in the workplace. And then it provides for employees to refer unresolved disputes to the CCMA. So that is basically the purpose of the Employment Equity Act. And then you move on to the advantages and disadvantages of this act. Okay, so the advantages and disadvantages are that. Okay, firstly, before we move on to the advantages and disadvantages, there are just things that I would like you guys to know about this act. And these things are called, let me just write fast for you guys here, the provisions of the Employment Equity Act. And these provisions are: number one, affirmative action, okay, which is an equal employment plan. Equal employment plan. And then number two, it's elimination of unfair discrimination. Okay, so these are policies that are actually put in place to ensure that no employee is discriminated against. And then we move on to the advantages and disadvantages in the act. Okay, so here it's basically the advantages and disadvantages on small and large businesses. Okay, so let's start with the advantages. The advantages is that discrimination in the workplace will be eradicated, since there's the provision for the Employment Equity Act, which aims to address all the issues that are pertaining to discrimination. So the final thing is that discrimination in the workplace will be eradicated, okay, because everybody will be treated fairly. And then the second advantage is that a defined process that makes it clear what procedures are to be followed. Okay, so employees can now not do their own things that favor others and doesn't favor the rest of the people. So there's a clear process on what needs to be done. There's a procedure that needs to be followed. Okay, and then another advantage is that injustices of the past can be rectified. Okay, and then businesses are in a better position to negotiate contracts with government. So these are all the advantages. Okay, and then the disadvantages would be that applying the employment equity quota does not always allow employers to appoint the best person for the job. Okay, so you can get to employ someone, but it might not be the best person for the job. It might not be the person who can actually perform correctly what the job needs to be done. And then another disadvantage is that additional resources such as human resources, financial resources, physical resources, and technological resources have to be made available. Okay, so that means more financial burden to the employer because they have to figure out a way on how to make these resources available. And then additional administrative duties to prepare such as statements of remuneration and benefits, as well as a full report of the implementation and monitoring the act. Okay, so that is also another burden for the business because they now need to maybe hire another person who will deal with administrative duties. Okay, because they pile up at that time. And then we have rights we have rights of employers and employees. Okay, so the rights of employees is that in sectors like the health sector, the labor court has found that testing employees to determine their HIV status is justified. Okay, so employers can actually run tests on their employees if only it is justified by the labor court. Okay, and then another advantage is that employers may perform psychometric testing of employees where it has been scientifically proven as valid and reliable. Okay, so that is one thing that that is another thing that employers don't have to worry about because they are allowed to run psychometric tests if they suspect that maybe one of their employees has a mental health disorder that needs to be attended to. And then another right is that employers may distinguish between or prefer any person on the basis of an inherent requirement of a job. Okay, and then the rights of employees on the other hand are that employees are entitled to equal opportunities and fair treatment when applying for jobs, so they cannot be discriminated against because all employees are equal. Okay, and then only psychometric tests certified by the Health Professions Council of South Africa, which is the HPCSA, may be used to assist employees. So employees actually have a right to ask the employer that, okay, you want to run a psychometric test on me, but is that psychometric test certified by the Health Professions Council of South Africa? And then if the employee says no, then the employee obviously has a right to say no, then I do not want to do the test until you get certification from the HPCSA. And then another right for employees is that if unfair discrimination occurs, an employee may refer the dispute to the CCMA for conciliation. Okay, so it is their right to do so. And then we have compliance and non-compliance. For compliance, employers must consult with the employees as required by the Act. Okay, so an employer can't make a decision without first informing the employee. They can't run like blood tests or perform a psychometric test without notifying the employee. Okay, so that is how an employer now complies with the Act. And then employers must disclose relevant information to all parties to ensure meaningful consultation. So that is another way of complying to the act. And then we move on to non-compliance. For non-compliance, it's basically what happens when an employer doesn't comply to the act. For example, if they run a psychometric test for an employee without having certification from the from the HPCSA, Health Professions Council of South Africa, then that is a problem because they may be fined or even jailed for a particular time. Okay, so they must always ensure that they comply to the act. And then we move on to the fourth act, which is the Basic Conditions of Employment Act. Okay, Basic Conditions of Employment Act. Okay, we first need to discuss the aim and the nature of the act. So the aim is it stipulates working hours, leave and employment contracts, and termination of employment. So it basically focuses on these things. Number 1, working hours. Number 2, leave. Number 3, employment contracts. And number 4, termination of employment. So it focuses on 4 things. And then the nature of the act is that the basic conditions of employment are part of the contracts between employers and employee. The conditions stipulate working hours, leave, employment contracts, deductions, pay slips, and termination of services. And then the purpose of the act is that it regulates the rights to fair labor practices, and it also establishes and enforces basic conditions of employment. Okay, and then the act also has to adhere to the rules and regulations set out by the International Labour Organization. Okay, and then this act has its implications on the employers and employees. Okay, so both employers and employees are protected in terms of the act. So let's say, this act protects both in the sense that, let's say an employee has 21 leave days, and now they take an additional day, which is now the 22nd day of their leave. So that this act now also protects an employer, because an employer can be allowed to actually give the employee a written or a verbal warning. Okay, and then we move on to the second implication, which is that a regulated environment ensures that processes are followed and prevents unfair treatment. Okay, so this act at all times prevents unfair treatment. Okay, and then the last implication is that many employees feel they are entitled to the rights as prescribed in the act, and sometimes take sick leave when they are not sick, simply because they feel it is their rights. Okay, so basically what they're implying here is that an employee mustn't now abuse their leave days or the act. They must try by all means to comply on the act, and they must actually do what is right. Okay, not what they feel is right. And then we move on to the rights of employers and the rights of employees. So here, an employer may ask for a medical certificate before paying a worker who was sick for more than 2 days at a time. Okay, employer may ask for a medical certificate before paying a worker who was sick for more than 2 days at a time. So this is done to ensure that an employee wasn't lying, and then an employee is being honest and is still acting professional. Okay, and then another right of an employer is that they may ask for proof that an employee's family responsibility leave was a necessity. At least that employee must bring, for example, a death certificate to prove that no, they needed this family responsibility leave for such and such a reason. And then the rights of employees, on the other hand, is that workers may demand their rights in terms of Labor Relations Act, such as that when workers are not working overtime, they must be paid the normal pay, and if they are working overtime, they must also be compensated as well for working overtime. Okay, and then full-time workers are entitled to 3 days paid leave for family's responsibility. And also, in these rights of both the employers and employees, it's always safe for both parties to refer to the contract, because the contract that was drafted actually states what is allowed and what is not allowed, the benefits of the employee, and so on. Okay, and then we move on to compliance and non-compliance. So basically here, in terms of compliance and non-compliance, what we need to know is that what an employer needs to do that is right is that they can never force an employee to work overtime on Sundays or public holidays unless the employee has agreed to do it. Okay, so they cannot forcefully say to an employee, you need to report to work, okay, on Sundays or on public holidays unless there's a mutual agreement between the two people. Okay, an employer may not force an employee to work overtime on Sundays or public holidays unless the employee agreed to do it. Okay, and another thing that they can do to comply is that an employer must provide employees with opportunity to take annual leave. Okay, and then another one is that a worker must receive a certificate of service which indicates the time period of employment. And then we move on to non-compliance. If a business does not comply with the regulations as set out in the Act, it could be held liable by the CCMA or labor courts. And then labor inspectors must be allowed to investigate complaints, question people, and make copies of records or remove records. So that is basically the first 4 acts. I'd like us to take a break and then later continue with the last 4 acts because it's quite a long lesson.